Hello and welcome to a lecture on the freedom of the press. This is a continuation of our discussion of First Amendment clauses, and this is how the free press clause reads in the First Amendment. Once again, Congress shall make no law abridging the freedom of the press, and we can ask the question again: does no law mean no law? And once again, the answer is no, it doesn't mean that there are governmental interests that are so important that it can restrict the freedom of the press. But the importance of this freedom is that it's seen as a way to protect other political and personal liberties. And there's an extended discussion in the text of the importance of an individual obtaining information to be able to speak intelligently on matters of public importance, and how maintaining a distinction between government and the press actually preserves democracy and keeps a free press, or keeps the press from becoming a tool of oppression. That discussion in particular is important. And once again, this concept of a priori or prior restraint came up in our previous section, but it is at the heart of the Free Press Clause jurisprudence, the concept of prior restraint. So let's talk about that a little bit. We should understand this already from the free speech section, but a prior restraint is a situation in which government reviews material to determine whether publication of the material should be allowed. And this happens before publication, and government can, under an a priori, imposition of an a priori restraint under the Free Press Clause, government doesn't necessarily punish the publication of the materials or those who publish the materials. It prevents their publication at all. Under the under the Free Speech Clause jurisprudence, of course, it's difficult to stop a person from speaking altogether without disappearing them, and then you've got a habeas corpus clause problem. But a priori restraint under the Free Speech Clause means if you speak these words, I will punish you. It's sort of just a notification to anyone who might speak. If you do speak, I'll punish you. Here, a priori means if you attempt to publish these materials, government will review them and prevent their publication, possibly. That's what a priori restraint means. So the concept of a prior restraint being applied to a press runs all the way back to the late 17th century, when William Blackstone, a great British English jurisprudent who had much influence on American colonial law, noted that no previous restraint should be placed on the press, and noted its benefits, the benefits of a free press for a free society. He says that if there were to be censorship, it could only occur after publication, and only if the activities violate some criminal laws already put in place by government. So now that creates certain problems, right? So let us say that a press knowingly publishes false information about an individual, which might violate laws against libel. If that happens, then government can punish those and censor the publication of those materials after they've been published. But one might argue that the damage had already been done. The first big case we need to talk about is Neer versus Minnesota. It's discussed in the chapter, and this case involved an attempt by the state of Minnesota to punish a publisher, part owner of the Saturday Press, who sort of saw the role of the Saturday Press as exposing corruption, bribery, gambling, and prostitution in Minneapolis, and attacking city officials. He published really scurrilous information about city officials, saying they were in league with gangsters and were engaged in corrupt practices. The text notes that Near held racist and in particular anti-Semitic attitudes and views, and those crept into his the language he used when castigating the city and city officials. So the question there is a statute authorizing the prior restraint of a newspaper consistent with the liberty of freedom of the press? In other words, when Minnesota moved to punish him for to punish Near for publishing these incendiary remarks, and also, getting the punishment ended up being the state of Minnesota going to a judge and attempting to obtain a restraining order prohibiting the newspaper from publishing in the future. Did that violate the liberty of freedom of the press? And the court says in a 5-4 vote, no, with the majority opinion written by Chief Justice Hughes. Hughes says, the right to be free of prior restraint is not unlimited. So once again, Congress shall make no law. Of course, in this case, we're talking about as applied through the Due Process Clause of the 14th Amendment, so we're also talking about state governments. But no law doesn't necessarily mean no law. There are recognizable limitations on the freedom of the press, and those are only in the most exceptional cases. And he says that such an exception might be going to war. He says here, the statute in Minnesota not only operates to suppress the offending newspaper, but to put the publisher under an effective censorship. And it goes on to say, although Hughes takes a strong position against prior censorship in Near, he acknowledges that the protection against previous restraint is not absolutely unlimited. So, let's be clear here. Is the statute consistent with the liberty of the freedom of the press? The court says, no, it is not, rules in favor of Near, and strikes down the restraining order that the state had obtained to keep Near from publishing in the future. Obviously, there was no exceptional event at issue here. The nation wasn't at war. The state just simply didn't like what was being published. So when does Near indicate prior restraint may be allowed? We need to answer that question and go through and look closely at the decision of the court, but they're only under exceptional circumstances involving national security or a disintegration of public order, threats to public order, could the state place a prior restraint on publication. The court, as it says here, the court has never dealt with the publication of war plans, but it has dealt with situations involving classified documents and national security. That's New York Times versus United States, heard in 1971. So this is the Pentagon Papers case. It involved the release of governmental papers related to incidents during the Vietnam War up to 1968. So this case is heard in 1971, and as the text notes, the whole case was dealt with in about 9 days from the attempt by the United States government to prevent the further publication of the Pentagon Papers. The case made its way out of federal district court all the way up to the Supreme Court, and the decision came down in only 9 days. These were secret studies and documents that have been photographed and given to the press by a man named Daniel Ellsberg, who had basically declassified these documents by making them available to the public. He'd taken classified documents and given them to the press, tended to embarrass the United States government, but it's important to note that while some of these documents were still classified, none of them related to ongoing foreign policy matters. They just tended to embarrass the United States and reveal some delicate details about its war effort. Now, the court did not uphold the decision, excuse me, it didn't uphold the request of the United States government to suppress the further publication of the Pentagon Papers, but the court split over why preventing their publication would be a violation of the Free Press Clause. So some justices, too, these free speech and free press absolutists, Black and Douglas, just said, no law is no law. Justice Brennan and Justice Marshall did not foreclose the possibility that extreme circumstances such as war would justify the suppression of publication of the press. And then two other justices, Justice White and Justice Potter Stewart, said that the only reason that these papers couldn't be suppressed is because government had failed to prove that the publication would, quote, result in direct, immediate, and irreparable harm to our nation or its people. So in other words, if the national government had borne its burden, they would have voted to suppress publication. Okay, so just tying up a few loose ends here. In terms of prohibiting content, we've got a series of cases here you might want to take a look at. Cox Broadcasting, the rule in that case was that if information is truthful and if it is public, then the state cannot restrict the publication of that information just simply because it might tend to embarrass public officials or erode public faith in government. Those are not sufficient reasons for suppressing publication. In the Simon & Schuster case, the court said that content-based prohibitions are antithetical to the First Amendment. So the New York State Crime Victims Board couldn't suppress publication of details about crime victims, just this particular content, this type of information. Even though the law was neutral or the policy was neutral, it still offended the First Amendment. And then Miami Herald versus Tornillo, the court says that government cannot mandate responsible journalism. So government can't go in and review articles and journalistic content to make sure that it is responsible. In this case, Miami Herald was accused of publishing information that it thought was true but was in fact false. They had not checked out their sources thoroughly and lived up to sort of ethical standards, and the state attempted to suppress publication. So the question here is, would this apply to the electronic media as well? Can government mandate responsible journalism for electronic media, blogs, online media sources, and things? And the answer there is yes, it does apply. Government cannot impose journalistic standards on even electronic media. In the Red Lion case, the court ruled that broadcasting can be treated differently from print media. This put into place any number of restrictions upon the broadcast media and an effective censorship of certain words. Many of you have probably, you're familiar with George Carlin's 7 Deadly Words, sort of comes out of this case and other cases like it. On the other hand, the court said that broadcasters do not have to accept editorials in the form of ads. In other words, a broadcast media can turn down what appears to be an ad or is purchased as an ad but ends up being a political statement by, in this case, the Democratic National Committee. Okay, thank you very much for your attention.